Hello, everyone. Matthew Tortora here again for the American Space Law Society with another SpaceX FAA Environmental Group lawsuit update. This one concerning the most recent filing on Friday, June 9th by SpaceX, which is a response to the FAA's response to SpaceX's initial motion to intervene. And despite actually being double the length in terms of pages, this one's 7, the FAA's was 3. It's actually going to be quite a short video just because a lot of this here is just SpaceX reiterating many of their points from the motion, as well as providing new case law and citation. So I don't think it's going to be as interesting to the general public as the FAA response was. However, I do think there's certainly some worthwhile takeaways from this, and a brief overview is going to cover it just fine. So starting from the introduction, there's actually a quote here that I tweeted out because I found it a little funny, but it certainly encapsulates the main argument between SpaceX and the FAA. So I'm going to read it and then I'll explain everything. Quote, Federal defendant's brief argument to the contrary ignores the relevant standard and misstates what is at stake in the case. So first of all, what made me laugh and what I tweeted out was the way SpaceX characterizes the FAA's argument as brief is like a doublespeak way or friendly way of saying that it was too short, not comprehensive enough, not substantial, just basically calling it bad, which I found really entertaining the way that they did that. But the second half of this quote is actually very good at encapsulating the argument as it stands. So SpaceX makes 2 points. The first, that the FAA ignores the relevant standard and misstates what is at stake in the case. So what ignores the relevant standard is in reference to as of right intervention. So I explained this more in depth in my previous video. However, I'll cover it briefly here. SpaceX is attempting to intervene in the lawsuit in 2 ways. There's what is called permissive intervention, which is, for all intents and purposes, discretionary on the judge. So the judge basically gets to decide for any number of reasons if the potential intervener would be allowed to become a co-defendant. And then there's what you have called as of right intervention. Now, as of right intervention is conditional. There's 4 conditions and they all must be met, and then the defendant is allowed to intervene. So I'll read these 4 conditions and then I'll explore what the contention is between SpaceX and the FAA. So the first condition is 1, the application to intervene must be timely. 2, the applicant must demonstrate a legally protected interest in the action. 3, the action must threaten to impair that interest. 4, no party to the action can be an adequate representative of applicant's interests. So the fourth condition here is where the issues lie. SpaceX is essentially arguing that the FAA is not an adequate representative of SpaceX's interests. Now, the FAA says that SpaceX isn't essentially concerned because this lawsuit isn't even about them. So they're actually disagreeing on both points 3 and 4 that SpaceX doesn't have a interest or adequate representation. Now, SpaceX they actually cite 2 or 3 cases here as to their position in this. The first one makes a really good point for SpaceX's position, and I'll quote it here, quote, the burden of meeting the last requirement is especially low in cases where, as here, the existing party is a government agency. Courts have often concluded that government entities do not adequately represent the interest of the aspiring interveners. And this is from a case called Funds for Animals Incorporated versus Norton. So this is actually a very pertinent case as it pertains to this argument by SpaceX. It's a very good citation. And they have actually 2 more. I'm not going to read it. I don't want to bore anybody. But SpaceX does a really good job of supporting this argument that they actually are essentially, they call it a very low minimal bar of entry in terms of the 4th element of as of right intervention. And then the second half of that initial quote, SpaceX is saying, misstates what is at stake in this case. So this is a larger, more, I guess, broad overview of the issues between the FAA and SpaceX. Essentially, SpaceX is saying that the FAA doesn't really understand the impact of the case on SpaceX. Now, for most people, I think, especially who kind of understand the intricacies of SpaceX and their operations at Boca Chica, this is pretty easy to understand why a complete environmental impact statement would disrupt their operations in Boca Chica. However, for those who don't know, SpaceX, their primary development facility for Starship is Boca Chica, and they actually were looking into the Roberts Road facility in Cape Canaveral by Kennedy Space Center. But they've actually fully reinvested their resources down to Boca Chica. They've actually shipped parts they were going to build at Kennedy Space Center back to Boca Chica, Texas. So in the initial motion, they actually say they've spent $3 billion on the development of Starship in Boca Chica. And I'm sure with this reinvestment in Boca Chica, and they plan to spend over $2 billion more in the next 2 years. So they are certainly doubling down and investing down in Texas. And they kind of illustrate that here. They argue that they have interests of both national and international importance, many jobs, contracts, etc., that are relevant to this case that will be impacted if this case were to be found in plaintiff's favors. And then they rebuttal the FAA's argument that SpaceX isn't concerned because essentially the FAA argues that the lawsuit is just about the environmental review process, not SpaceX. SpaceX comes back at this with the quoting the actual initial text of the lawsuit from plaintiffs in the second prayer for relief, which is like what they expect to happen if the lawsuit were to be found in their favor, which is, quote, I'll quote it here, seeking to vacate and remand the FAA's decision to approve SpaceX's application for a vehicle operator license. So this is essentially saying that if plaintiffs were to win this case, that the FAA would have to essentially conduct a full environmental review process with the environmental impact statement, which would take upwards of 2 years, and they would not be able to launch Starship during this time, which I don't need to say, I don't think, but would be detrimental. Starship development would basically have to stop and have to find someplace else where it's Kennedy Space Center or somewhere else to develop Starship, because if they can't launch and they can't test, it's essentially over for Starship. I don't want to be doom and gloom, and I certainly think that's not necessarily in the realm of possibilities, but that's certainly what SpaceX is arguing here, that there's a potential major disruption to their operations if plaintiffs were to win, which is why they have a stake in this lawsuit, basically. So that is kind of it for this filing as it is, just because, again, there's a lot more, and I encourage anybody to read this. I'll put the link with the video to the PDF. You can also find it pretty readily available. But just, it'd be good to read, but I don't think many people are going to be interested in a lot of the case citations here. I've kind of discussed everything that's relevant going forward. However, moving forward, just expectations for the next couple of weeks and up to a month, basically. We expect July 1st is the deadline for the FAA to actually file their response to the actual lawsuit, not this little dispute, to the actual environmental groups. So we should see that around July 1st, hopefully sooner, but closer to that. And we should also see the judge's ruling on SpaceX's motion to intervene. I don't want to dive into speculation or like personal opinion, but I do certainly think SpaceX makes a strong argument between their motion to intervene and this response. They have a lot going for them, and if the FAA, I'll hold my breath until they maybe file a response to this response. However, as it stands now, the SpaceX did a very good job of arguing for themselves, and I think it's very likely that they will actually be admitted as a co-defendant or an intervener defendant. Either way, just because if it's not on grounds of as of right intervention, it'll probably be permissive intervention, just because neither the plaintiffs nor the FAA objected on grounds of permissive intervention. So I think it's very likely, one way or another, SpaceX is getting into this lawsuit. All right, that is pretty much it for today. I know it was very brief, minor overview. However, I do think there's still some worthwhile takeaways. Just preparing ourselves for the next month or so of back and forth, maybe from the FAA and SpaceX, before we get to kind of the main event, which is the squaring off between the plaintiffs and the defendants, which is kind of getting back on track to what this lawsuit should actually be. But certainly stay tuned on my socials, on the American Space Law Society socials. We will be updating everything along the way. I'll be posting these videos every time we get a new filing, so certainly stay tuned. And if you're interested in space law outside of this case, certainly check out the American Space Law Society. We do stuff on international law, international space law, the future of space law, Certainly check us out. I'm sure if you have any minor interest in space, you will find some niche on our website, spacelawsociety.org or .com, either work. That is basically it for today. Thanks for watching.